Happy day. Welcome to M.O.P classroom. This is Krupa, Assistant Professor, Department of Management Studies, BBA Shift 1. My topic for the day is capacity to parties. Let me shortly introduce about what do you mean by capacity of parties. Capacity of parties. This is the third essential element of contract, and this is the most important contractual requirement which is coming under the capacity of contract. What do you mean by the contractual capacity? The contractual capacity refers to the legal ability of a person. When is a person competent to contract? When is a person capable to enter into a contract? So a person can enter into a contract when he attains his majority. That is, a person who is less than 18 years of age cannot enter into a contract. When a person enters into the contract is called that it is not enforceable by the law. Second thing is, the section 11 of the Indian Contract Act defines the capacity as every person is competent to a contract who attains the age of majority according to the law. Who is a minor? A minor is a person where a guardian is appointed for him, and after completion of this 18 years of age, the person will attain his majority. The second case will be on attaining the age of 21 years. When is that situation? When the minor's property is under the supervision of the court, then it is not 18 years of age, it is 21 years of age. Let me go into what are the position of agreements under the minor. The first provision is validity of an agreement. A contract entered with a minor is called as a void ab initio. It is not enforceable under the law. Why do we call it that the contract is void ab initio is? Void ab initio, the meaning void ab initio is from the beginning of the contract, it is stated that it is not a valid contract. It is not enforceable by the law. I can explain you this void ab initio with the help of a famous case law, that is M.O.P versus Dharmadas Ghosh. Dharmadas Ghosh is a person who is 18 years of age. Knowingly, Dharmadas Ghosh has entered into a contract. He has borrowed a money from a money lender. He has also told that he is of 18 years of age, where when a contract is happened between M.O.P and Dharmadas Ghosh, it is termed as the agreement is void ab initio, because the subject matter of the contract itself is wrong. What is the subject matter of the contract here? The person should have crossed above 18 years of age, but still both of them knowingly the person had entered into the contract. This is called as void ab initio, and the contract cannot be proceeded, or if at all the minor fails to make any payment, the court will give the judgments telling that the person cannot be claiming the compensation amount, because both of them knowingly they have entered into a contract which is termed as void ab initio, which they are not supposed to do. Second one is no estoppel against a minor. So first point, we saw that the contract is void ab initio. From the beginning, the contract states that it's void ab initio. There's a mistake which they had done there. Knowingly, they have done the mistake. The same thing, no estoppel against a minor is, even though the minor has entered into a contract, since he is a minor, there's a lot of provisions for the minor telling that the minor can plead his minority. If at all the person has wrongly entered into the contract, he can always plead the court for his minority. But there's also one of the major disadvantage here. If the court is giving them such kind of apology, or if the court is allowing them such kind of an pleading the minority person will end up making a mistake. Maybe it can be of ignorance, or wantedly the person can make a lot of mistake. So the minor has also a right of estoppel against a minor. Fraudulent representation. So the first one, knowingly the contract, they are not supposed to enter into a contract. Secondly, if the minor has entered into the contract, he can have a chance of pleading for the minority. The third one is a fraudulent representation. Here, the intention of the minor is to cheat a person. The minor is cheating a person by falsely claiming his age. Maybe if the person is not more than 18 years of age, but the person has represented himself that he has crossed the 18 years and is more than 18 years of age and he is entering into a contract. If any case like that, and if the person able to find out that he has falsely represented the age, the court will not be for the minor, the court will be against the minor. In this case, the court will definitely give a judgment telling that the minor need to pay the compensation for the aggrieved party. Here, the main clause is they need to be following the law of restitution. What do you mean by the law of restitution? It is called as restoring back. So, the aggrieved party has been falsely represented by a minor and any damages which has been caused by the minor has to be compensated for the aggrieved party. The next provision is no ratification against the age of minority. Ratification restored back. Ratification is not possible on attainment of majority. A contract which is called as void cannot become a valid contract after attaining the age of majority. That is, a contract entered below 18 years of age has to be cancelled when a person is attaining the age of maturity which is above 18 years of age. The same contract cannot be continued. The same contract which is called as void cannot be turned towards valid, but the contract needs to be completely stopped there, and when the person has attained his age of majority which is above 18 years of age, a new contract have to be started, but the contract cannot be ratified. Next one is liability of necessaries. This is stated under section 68. The minor's guardian can claim for the compensation the amount spent for the minor's necessaries. When we call it as a necessaries, the necessaries of the goods can be called as the essential services, the goods and services which is required for a day-to-day purposes, which is more important. Here, when we call it is as essential, it is essential and not luxury. So, there is a lot of difference between essential and the luxury. The minor's property, the guardian can compensate only for the necessaries and not for the luxuries. When it is for food, education and shelter, that can be compensated, but the minor ends spending like 10 coats or 20 coats where that is not called as necessaries and that is called as luxuries, where that amount cannot be compensated by the guardian. Next one is contract by minor's guardians. Yes, the contract which has been entered on behalf of the minor by the guardian is accepted, provided if it is within the scope of authority, if it is enforceable by law. If the guardian also is not entering a contract which is lying within the scope of authority, then that contract cannot be called as a valid contract. And next one is minor as a beneficiary. Minor can act as a beneficiary or minor can be included as a beneficiary. When we say about beneficiary, it can be called as a gift. A minor can receive anything in the form of a scholarship, or a minor can be getting it any form of a trust benefit. So, minor can also be as a beneficiary. Next one is contracts that are entirely in favor of the minor. Yes, any contract which is entirely in favor of the minor, which comes under the enforceability of contract, then that contract can be a valid contract. Minor in partnership. Can minor enter into a partnership? Minor cannot become a partner, but minor's property can be used in the partnership. Minor cannot be personally liable for anything. Only the property of the minor can be used in the partnership, and minor cannot be personally liable for any of the firm's losses. Minor and tort, civil wrong. What do you mean by this tort? A tort is a kind of consequences. A tort can be defined as a legal consequences, where this legal consequences can be classified as civil tort or the criminal tort. Criminal tort is something which is punishable against the Indian Penal Code, but this civil tort is something where you have a remedy for it. It can be, the remedy can be done by compensation for the loss which has been caused. So, when discussing about this point, is minor liable for this civil tort? The minor, yes, he is liable for the torts, when it is categorized into two. Number one will be if the minor is causing any damages or any misrepresentation, and if the act is independent of any contract, then the minor is held liable for its tort. Second point is, but if the tort is closely connected to a contract, then the minor is not liable. Let me explain this point with the case law. Bernard versus Huggies. This is a famous case law where the fact of the case is about Mr. Berner, a minor. He had hired a horse from a stable under the condition that it is to be used only for riding and not for jumping. But the Berner ignored the restriction and he has used the horse for what he is supposed not to use. He has used a horse, he has overridden, he has also used the horse for jumping. What happened? When the Bernard has used it for overriding and he has used it for jumping, the horse became tired, the horse fell down and the horse died. So now this case is about mistake is on Bernard or the mistake is on Huggies. The mistake is not on Huggies because the Bernard, being a minor, is being clearly told that it is a sick horse or the horse can be used only for riding. The horse cannot be used for overriding. In spite of giving this kind of a warning, and if the Bernard is doing that, then it is the mistake on the Bernard and it is not the mistake on the Huggies. So here, whatever has been told, it is under the contract, but the person has not listened, and because of his tortious acts is nothing but negligence. So because of this tortious act, it ended up saying that the horse is no more and the Bernard has to be liable for whatever loss Mr. Huggies is. But this case established that the minor cannot be bound by contract, but they can be held responsible for the torts and they are separate from the contractual applications. Position of person of sound mind. So let me just give you a quick recap. When we are discussing about a competent of the contract, I was telling you that the person should attain an age of 18 years, right? He should not be below 18 years, he should be above 18 years. The person should be of sound mind, and anything which is considered as, any contract which is considered as opposed to the public policy will not be coming under the essential elements of the contract. The second point is the position of person of a sound mind. Who can enter into a contract? Any person who is stable, any person who is of sound mind alone can enter into a contract. If a person is a drunkard, if a person is a lunatic, or if a person is unsound mind, then those persons are not eligible to enter into a contract. But here, it's not that the drunken person or an intoxicated person is always drunken. So when at the time of a drunken, the contract cannot be entered. Maybe after the person is cautious, the contract can be entered. So whenever the person is of unsound mind, there is no contract, but that unsound mind turned to be a sound mind, there can be a contract. Persons disqualified by law. Person disqualified by law is, there are certain persons who are legally disqualified from the contract due to the status or it is due to the nature of law. So who are the persons who are legally disqualified from the law? First one is any kind of an person, there can be a reason for disqualification. He can be an alien enemy or he can be an adjudicated insolvent. There are a lot of reasons where we can classify the person who is not coming under the legal dispute. Second thing is the foreign sovereign, because foreign sovereign here we can actually sue him under the Indian court, but for that we need to get the approval of the central government. Next one is the convicts. The convicts is nothing but the person who are under an imprisonment, or any person who is called as an adjudicated insolvent cannot enter into a contract. And any insolvent, a person is under the bankruptcy, the person is under a legal issue with any bank, he cannot also enter the contract. Summary of the key points. A quick recap of what we have saw through all this is, we started with the third element of the essential element of contract, which is called as a capacity of parties. So when we say a person is capable to enter into a contract when he is above 18 years of age, when a person is of sound mind, and thirdly, the person should not be disqualified by any law. So on these three grounds, the capacity of the person is competent to enter into a contract. Therefore, we can conclude that a person who has attained 18 years of age, or a person who is more than 18 years of age, and the person who is of sound mind, and the person who is not disqualified for any law can enter into a contract. Thank you for listening. Hope you understood. Like, share and subscribe M.O.P Classroom.